So I just bring that up just because people always ask about the international landscape, and we may touch on it just a little bit. But it's just a little interesting factoid that again, as we see, the global environment that we live in, these are just some of the parameters, and things change, and how things have changed. So let's see if this works. Oh, there we go. So promote the, right, so this is that was the piece of the Constitution where Congress was given that power. So let's talk a little bit, this is kind of the big picture slide. So where does intellectual property law come from? And so in America, we have copyrights, which are solely creatures of federal power. Okay, only the federal government can grant you a copyright. So you go to the Library of Congress, to the Copyright Office, you pay them $65, you send in your specimen, and magically after 3 or 4 months, you get your copyright. Very easy to protect, very straightforward. In fact, for most of our clients, I rather teach them how to do it, and then they can file their own. And I mean, we'll be glad to do it, but that's something that's relatively simple. And for a university, a lot of copyrights are created every single day. Every time you hit save on your computer, there are copyrights that attach to whatever you've created. So that is one of the most common forms of intellectual property at a university. Trademarks, America is very unique in this regard, and common law countries are as well, where we actually not only have federal trademarks, we have state trademarks. You can get a Texas state trademark. But trademarks are also common law. In other words, your usage in commerce and the association of your goods or services with your name, just by putting your shingle out there, starts to create trademark rights. So you can have a shop down the street and sell sandwiches and have a cute name, and you have already created trademark rights. Trade secrets, again, America's a little unique in this regard. We have no federal trade secret laws, except for some espionage things having to do with foreign powers. But trademarks, trade secrets, are creatures of state law. States write their statutes. Texas is also unique in this regard in that we have no trade secret statute. It's all common law. It's all just the creation and the traditions of trade secret in Texas. And then finally, well, there are contracts, which I also consider part of intellectual property, because there are so many things that deal with intellectual property. I mean, most contracts will have some kind of provision having to do with either, your right to your name, or being able to include your name in some kind of collaboration or some confidentiality associated with it. And that, of course, also protects intellectual property. Very heavily involved in contracts having to do with employees, especially if you have any kind of technical employees, where you want to, protect them from bringing something bad into your company, or from, your company using other folks' stuff, or people taking yours. And finally, patents. So patents are solely creatures of federal law. That's the way it is in the rest of the world as well. There is no such thing as an international patent. Every patent is still only for an individual country. And that includes Europe. You can prosecute one patent for the whole EPO, for the entire region. But once that patent is granted, you still have to validate it in each member country. So there is no such thing as regional patents even. You still, at the end of the day, still have to register in every single country. And your patent for that country only protects what occurs within those borders. There's no talk of having some kind of international patent. There is an international patent filing system. You can have an international application, but not an international patent. And we'll talk about a little bit about that later on. So in the United States, what is patentable? So now I'm just going to jump straight into patents. What is patentable? Well, it has to be something that is new, that is useful, and that is non-obvious. And it has to fall within the categories of things that the patent law says is patentable. Compositions of matter, for example, drugs. That would also include apparatuses, devices, or methods. A new way of making aspirin. It is a method. Or now, for the last 10 or 15 years or so, software is patentable. The functionality that has to do with software. It does have to be implemented in some kind of machine or device. But it is patentable. So what is not patentable? Well, this is not statutory. This is all just based on traditions and case law. But algorithms per se are not patentable. Laws of nature are not patentable. Things that are protected by other forms of intellectual property, like copyrights, written works, things like that, those are not patentable. because there's another avenue that you can use to protect those things. So whatever it is that you invent has to be new, it has to be useful, and it has to be non-obvious. That it is new means that nobody has ever done it before. Nobody has ever discovered this before, nobody has ever made it before. That is useful, it means that it has some use. There's one of my law professors would always talk about that for a long time the patent office was saying that transgenic corn was not useful. And my law professor would argue with the examiner, says, well, but you can always use it to make whiskey. So it obviously has some use. And eventually all those patents were allowed. And it's the ag industry is very, very big. Because of those fights, they had to be, taken care of about 20, 25 years ago. And that it is non-obvious. And that is usually the hardest part. That is the hardest fought battles that we have as patent lawyers with the U.S. Patent Office and the examiners have to do with what is obvious. And obviousness has to be found within the context of the prior art. In other words, you have other people that have discovered things, and none of us works in a vacuum. Every single one of us, no matter what area we're in, there's folks we've learned from these folks, and these people have published this, and these people have published these other things. And the patent office will take the position that, a skilled artisan would have taken this piece, and this piece, and this piece, and put them together the way you did. It was obvious. Once you knew these three things, the next logical step was to put them together. And our job as investigators and as patent attorneys is to convince them otherwise. To say, no, wait a minute, the skilled artisan didn't say that. Or the skilled artisan, this piece of art actually teaches against what we're doing. It said this wouldn't work, and we're proving to you, actually, it does work. And so usually the fight of obviousness has to do with an examiner putting together 2 or 3 pieces of art and us having to argue why they wouldn't have done so. So the obviousness question is a very, very difficult question, and it is something that as we do work, and as I'll discuss in a second about how you help your patent attorney and the licensing office, is to be able to make a very solid argument and build into a patent application the argument as to why something is not obvious. So let's talk a little bit about costs. So how do you get a patent? It is not an easy process. It's a lengthy process, and it's an expensive process. So usually you engage a patent attorney or a patent agent to write your patent application. And you have to submit to the U.S. Patent Office a disclosure, a written disclosure, that includes a description of what it is that you're claiming, these things called claims, which is using words to describe intangible property. So when you define a piece of property, a piece of land, you usually have some kind of marker. You have a marker and you say, for marker A, you go 47 feet in this direction. To marker B, you go 27 feet in this direction. And so you describe it by having markers and distances and angles. Well, a patent claim is the same thing, but we're using words to describe what it is that we're going to protect. A new way of making aspirin, where we take this component, mix it with this component, you get a product, you then heat it, you throw in another chemical, you have some kind of reaction, you then take that product and then you isolate the aspirin. That's a method. You have steps in which you describe how you do it. Or you can have a composition of matter. You can say, this small piece of DNA that happens to have this sequence and is useful for this purpose. You have some kind of structure and some kind of function. And you have to describe that, and your application has to enable a skilled artisan, somebody else, your competitors, how to make and use the invention. And then you also have to provide the best mode of doing so. And so those are the requirements. And there's a format that you're required to follow that's suggested, but when you don't follow it, the examiner tells you to fix it. And that is kind of our skill. A patent application has really 3 audiences. The first one is the patent examiner. You have to get this application past the patent examiner. Patent examiners at the United States Patent and Trademark Office are subject matter experts. In the biological arts, they're pretty much all PhDs. In the engineering arts, they're engineering specialties in whatever chemical, electrical, mechanical, whatever area they're in. The software folks, guess what? They're all computer science majors. So depending on the area, folks that do oil and gas, guess what? Those are folks who are experts in oil and gas. So this is not somebody just off the street. This is an expert. And they know this art and that field. This is all they do all day. So they know what's out there, and they understand the law. They get trained in the law. And so, I mean, they do a very sophisticated analysis of what the prior art is and apply it to your patent application. So we have to convince the patent examiner that it's patentable and that the claims that were written are new, useful, and non-obvious. We also have to convince a potential licensee or a startup that we are protecting the intellectual property that they need to protect for their business. In other words, if you think that you are going to have product A this year, B the next year, C the next year, we need to encompass and try to protect all of that intellectual property with our patent claims. And then finally, the third audience that I like to talk about is a potential infringer. If I am a devious infringer and I want to avoid your patent and your patent claims, I need to figure out how I'm going to get around your patent. And the key is to write your patent to begin with, taking their perspective. What change could I make? What step could I leave out that I would use to take advantage to avoid your patent? And so when we build that all into the patent application, we've covered our three audiences and we've covered our bases. Potential products, potential infringers, and making sure that we are able to convince the patent examiner that what we're doing is patentable. The cost, well, it really depends on the technology. But to give you an idea, a major system of the state of Texas puts their average cost of patent, kind of soup to nuts, at about $25,000 each U.S. patent. That's one U.S. patent, from capturing the disclosure, writing a patent application, filing it, prosecuting through the U.S. Patent and Trademark Office, paying the issue fees, and paying the maintenance fees. So it is not an inexpensive process. And that's assuming that you get and succeed all the way through the process. There's no guarantee that you'll be able to get a patent at the end of the day. And that's one U.S. patent. So, and I'll talk actually at the very tail end about the Patent Reform Act. These are just some examples that I like to put up there. And unfortunately, it's in really, really small print, which is why having the really small print on paper is useful. Of different things that you can protect. And most of the times when I give this talk is to a biotech-heavy audience. And since we're at the Health Sciences Center, I figured we would focus on that. But the purpose of this slide is really to push your thinking in terms of what is patentable. What can I protect via a patent claim? Well, of course, the obvious things, equipment, devices, an apparatus, a hat tipper, things like that we're kind of used to looking at. Of course, biologics, pieces of DNA, sequences that have some kind of use that nobody had ever discovered before. I mean, that becomes more and more challenging now that the genome has been sequenced. But there's still plenty of things that can be patented, especially in the types of kits, diagnostics, assays, medical diagnostics and therapeutics. Proteins, peptides, mutants of things that have never been made before. We're seeing a lot of crossover technology, so bio-nano-hybrids, where you would have components, and I'll show you an example of one, where you have an apparatus, but then you're using biologics to take advantage of some of the features of these devices. Something that folks don't always think about, cosmeceuticals, nutraceuticals, and it's a huge industry, and then all the ag applications for a lot of these things, especially in medical centers, we're always thinking humans, but the ag applications are actually much easier to get because you don't have to deal with the FDA, you deal with the USDA. So it's a lot easier to get past those regulatory hurdles when it comes to working with animals than it does with working with humans. Or if you're in the plant side, again, it's just different. It's not FDA you have to deal with. The FDA, of course, as we know, is very cost intensive to get through that regulatory process. Just because you have a United States patent doesn't mean that you can make it and sell, because you have other regulatory agencies, the EPA and others, that may also regulate what it is that you're trying to sell. So I may be able to get you all sorts of patents for biological compounds, but until you get the FDA to say you can actually use this in humans, there's not a whole lot you can do. So you have to keep in mind that there are many different hurdles and that there are many different opportunities to be able to commercialize and meet the mission of the university. Remember, this is about the mission of the university. And that is, the university is here to educate its students. It's here to help the public. This is a publicly funded university. And its mission is, and what you're doing is to promote science. And we have to remember that. It's not always about commercialization. There is a mission, and that mission is to be met. And that's why we're all here. And so it's important to remember that. Processes, methods. A lot of inventions can be found in solving problems. Nobody had ever been able to, get this molecule to cross the blood-brain barrier when we found a new way of doing it. And so those are different things, and of course, we'll talk a little bit about business methods. Most of those are tied into systems. So, and you can even do financial instruments as long as they're tied into some kind of system. Okay, these are all kind of new, the bold new world of intellectual property protection, and there are many fights over that. My business partner is really more the expert on those types of things. But again, you need to look to see whether it's new, useful, non-obvious, and it's patentable subject matter. So I wanted to give some examples here, and probably the